So we now turn to Rule 608B, and that says that a lawyer can inquire into a witness's specific acts that demonstrate a lack of truthfulness or truthfulness that obviously would impeach or rehabilitate the person's testimony. However, you are not allowed to bring in extraneous evidence to prove this. So, if you're cross-examining a witness and you're trying to tear that person's testimony down, and this person has previously lied on a bank application, that means you can ask the witness if he or she lied on a bank application, but you cannot present extraneous evidence. You cannot introduce the bank application into evidence to prove that the person did it. So we look at the case of People versus Segovia in Colorado, and in this case, you had a child witness, and the prosecution had offered this child witness, and the defense lawyer is cross-examining the witness, and wants to show that the witness had previously stolen money from the witness's mom's store. And the trial court sustained the objection to this testimony under Rule 608B. And it's not really clear from the portion of the case we have why that's the case, but the court goes into the difference between intrinsic evidence and extrinsic evidence. So if we wanted to offer the videotape of the child stealing the money from the store, you couldn't do that because that is extrinsic evidence of this act that the defense claims undermines the witness's character for truth-telling. If, however, you want to ask the child, isn't it true that truth-telling is very important? You don't always tell the truth, do you? Isn't it true that you stole from your mom's store? That question may be allowed if, in fact, the court finds that the instance asked about actually bears on this particular witness's character for truth-telling. And so that's when the court goes into a question of what sorts of bad acts are probative of a person's truth-telling or not. And the court says that Colorado courts haven't specifically looked at whether shoplifting is probative of untruthfulness, but it says there are basically two categories that Colorado courts have examined, those in which they've held to be relevant to truth-telling, and those are making false statements to the police or on bank loans or filing false tax returns, for instance. And then things that Colorado courts have said are not probative of truth-telling, and those are acts of violence and drug use and bigamy, oddly enough, Colorado courts have held are not relevant to truth-telling. I would think that actually having two wives, I assume it's two wives, it could be two husbands, but I would assume having 2 or 7 wives would be relevant to truth-telling, because I assume implicit in any marital vow in the United States is the idea that you aren't also married to someone else. But courts have held that, in Colorado anyway, that bigamy is not probative of truth-telling. But which of these two categories does shoplifting fit into? Those things that are probative of lack of truth-telling, or things that aren't? The court holds that there are 3 views out there in judicial opinions. One is the broad view that basically anything bad you ever do, if you ever use drugs, if you ever hit somebody, that your willingness to break the law suggests something about your willingness to tell the truth. Then the court holds that there's a narrow view, and that narrow view is that only crimes or bad acts that have as elements a lie contained in there, like false statements, perjury, fraud, or embezzlement, things that actually affirmatively require a lie as part of the definition, actually fit within the definition of those things which are probative of lack of truth-telling. And not surprisingly, when a court sets something up where they say, here's the broad view, here's the narrow view, there's a pretty good indication when they set something like that up, whatever they define as the middle view, they will then take. The middle view says if you look at the act itself, if the act itself suggests a willingness to, in this court's view, a willingness to get an unfair advantage over someone else. That's the standard that the Colorado court is defining as something that is probative of untruthfulness. Now, as the court's laid out, you're going to have a variety of judicial opinions on this. So, obviously consult your local listings for the specifics. But if you look at this particular court, it's saying those things which, would give a person an unfair advantage over another, such as shoplifting. This wasn't something that you earned. This wasn't something you bought, but you're going to take. Theft generally would be probative in this court's view of a willingness to get an advantage over someone else, which may include actually lying. Which is just different than like being a violent person or a drug user, or willingness to break the law generally. So again, depending on the jurisdiction, how your particular jurisdiction is interpreting this rule under 608B, you'll get a different answer. But the court has laid out all three that some courts, any criminal violation is something that's a probative of lack of truth telling. Some say it's got to be much more narrow than that. It has to be an actual lie that's part of the story. And then this middle view, anything that gives you an unfair advantage, a willingness to get an unfair advantage, is probative of a willingness to lie. And so the court in this case sends the case back down to the lower court, saying that the trial court improperly looked at Rule 608B as not applying, because in no small part the trial court thought that this was governed by 404B, bad character generally, and not specifically under the rules that relate to either the impeachment or the rehabilitation of a witness, which are 608. And in this case, because we're inquiring about a specific act, relates to 608B.